Please be seated. Next case is Brevard County versus our State of Florida Department of Revenue. You may proceed whenever you're ready.
May it please the Court, my name is Scott Knox. I am the Brevard County Attorney representing Brevard County in this case. Your Honors, we are here before you tonight, or today, seeking an order reversing the lower court, which had the effect of removing approximately $4.6 million in revenue from Brevard County, which is facing, as all agencies are facing these days, substantial budget cuts which are affecting people's lives. And so this $4.6 million we're looking to have reinstated is critical to the county.
Mr. Knox, I just want to advise you, I can't hear you.
Okay, I'm sorry. I'll step closer.
Okay.
The fundamental difference that we have with the Department of Revenue in this case relates to their construction of Chapter 200 Florida statutes as it applies to maximum millage rate determinations. The department was of the opinion that that chapter impacted counties by requiring a determination of a compound annual growth rate in taxes over a 6-year period based upon what they conceived to be a maximum millage rate for the entire county. And in contrast, the county's position is that their job as the department was to determine that compound annual growth rate for the county as a whole, but they had nothing to do with the determination of the maximum millage rate for each individual taxing unit that the county is responsible for levying taxes. As a consequence of the department's...
Okay, but let me interrupt because maybe I didn't understand something here. You spent a lot of time in your brief talking about the determination of millage for individual districts versus the county as a whole. It seemed to me your real argument was that the fact that the county included these, or the Department of Revenue would not include the fire district in your calculation for
compound annual growth rate.
Compound growth. So help me a little bit. How does the first part of your brief help you with that argument? It never became clear to me in reading your brief. The question of whether they were treating, independent or districts separately or combined, how that fit in with your later argument that you should be able to include this fire district in your compound growth. Can you build that bridge for me a little bit?
Yeah, I think I can, Your Honor. We're looking at the whole statute, all the provisions in Chapter 200, from 200.065, which determines the rollback rate, all the way through the actual maximum millage rate determination. Under the statutory scheme, the department's role was to do one thing, which is to determine the compound annual growth rate. They did that, but they did that by going into an exclusion that applied only to the maximum millage rate calculation, which applies to individual taxing authorities. So by taking that Section 4D exclusion, saying that the fire control districts should be treated like independent special districts, they essentially took what was an individual taxing authority calculation and expanded that to include their role as in the determination of the compound annual growth rate by removing fire control district revenues from that calculation, whereas the statutory scheme contemplates an individual determination for each one of those individual taxing authorities, as opposed to what they did. The connection is simply that they had one role which was independent from what the actual way in which the statute works, which was to allow individual determination of maximum millage rates for individual taxing authorities.
Let me get to the specific argument concerning whether the 4D exception, how that was to work. You would agree that under the definition of total county and ad valorem taxes levied, that independent districts would not be included in that calculation?
That would be correct.
Okay. Then I go to the 4D And the language says, for the purpose of calculating millage rates for 2007-8, these districts, the predominant function which is to provide emergency, medical, or fire services, shall be considered an independent special district and shall not be included for purposes of calculating the maximum millage rate under subsections 2 and 3. Subsection 3 deals with municipalities, so we're not concerned with that. Subsection 2 specifically goes to how to apply the limitations on millage to calculate the millage rate. So if this particular section, the exact wording of this language says, for the purpose of that calculation, you shall consider these districts as independent districts, and you've already told me that independent districts are not included in the calculation, how do you get around the specific wording of the statute?
The exclusion applied only to subsection 2. It did not apply to subsection 7, which is where the compound annual growth rate requirement comes from. If the legislature had said you exclude it from subsection 2 and subsection 7, I would agree with you. But it doesn't say that. It says you exclude it from subsection 2. Subsection 2 only applies to individual maximum millage rate calculations for each separate taxing authority. The county has 18 of those it levies for. That's got nothing to do with the compound annual growth rate. That's a separate item under subsection 7 that the DOR was responsible for preparing, and that calculation required the inclusion of all MSTUs. There's no exclusion in subsection 4D from the requirement that all MSTUs be included in the calculation of compound annual growth rates. In fact, the definition of total county ad valorem taxes levied includes all MSTUs. There's no exclusion in that definition for fire control MSTUs either. So I would say you were right if 4D had said it's excluded from subsection 2, 3, and 7, you'd be right. But it doesn't say that. It says 2 and 3 only. So I think that's why we're having the discussion between the compound annual growth rate section, which is 7, and the maximum millage rate calculation section, which is individual and applies only in subsection 2.
Okay, go on. I'm trying to look quickly at subsection 7 while you're talking.
Okay. DOR did, to follow up on what you're saying, Your Honor, DOR took that exclusion in subsection 4D that applies only to subsection 2, and it just had this idea that there had to be a maximum millage rate calculation for the entire county, which is not the case. The only thing that has to be calculated for the entire county is the compound annual growth rate, and that's under subsection 7. But DOR took the exclusion and applied it to subsection 7. They applied it to subsection 8, which has nothing to do with the calculation of maximum millage rates. It has to do with the calculation of maximum total county taxes levied, which basically, so they took their overall approach to this was to say they were independent special districts for all purposes under the statute, where in fact the only purpose that they're independent special districts for is the calculation of the individual maximum millage rate for a fire control district under 4D. If you look under 4D, it says we're not going to make the calculation for the individual maximum, for the individual fire control unit under 2. We're going to make it under 4. We're not going to make it 91% of the rollback rate under 2. We're going to make it 97% of the rollback rate under 4, because that's the specific legislatively determined maximum millage rate for independent special districts. Under 4 sets that out, the first sentence. So what all 4D did was to say, we don't treat you under 2. If you're a fire control district, we're going to treat you under 4 as an independent special district for calculating your individual maximum millage rate. None of that has anything to do with the basis upon which the department had to determine compound annual growth rates. That was specified as being the total county taxes levied, which is a defined term to include the county's fire control MSTU and all other MSTUs. And that affected what the department did.
So let me paraphrase what you're saying in language that I can understand.
Okay.
All you're saying that 4D did was allow the fire control districts to levy 97% of their tax rate, notwithstanding what the growth rate was.
That's correct. That's correct. That's the only effect it had. Obviously, the legislature thought fire control was worth keeping more money than the rest of the types of tax entities, because this whole statute was designed to require local governments to reduce their taxes. And they felt fire control was more important, I guess, than the rest of the kinds of services the counties provide, and they put it at 97 instead of 91 or 93 or whatever percentage it would fall under. So it's the county's position simply that the department took the wrong approach to this from the outset, looking at the compound annual growth rate as part of an overall county picture was okay, but you can't take that and transfer it over to the maximum millage rate determination for individual taxing units, because the legislature just said, as you pointed out, Your Honor, you take it from 91% of maximum of your rollback rate for a fire control district, and you move it up to 97% of the rollback rate, because we want fire control to get more money than we do others. That's the only effect of that exclusion. Thank you.
May it please the Court. My name is Joseph Mellichamp. I'm Special Counsel to the Office of the Attorney General, representing the Department of Revenue. What we have here today is a rather simple case. The trial court simply stated the only issue on page 1 of its order is whether the calculation of maximum millage rate for counties under 200-185, 2A, and 4D for fiscal year 07-08 included or excluded fire, rescue, and EMS districts, we'll just call them fire districts, that had been dependent on the county prior to this legislation. And what the legislature did in 2007 was a proportionate response to...
The microphone doesn't like you for some
No,
reason.
it doesn't. I've never done anything to it. I don't know what its problem is. I like electronics except for my computer. The legislature was faced with a 99% increase of ad valorem taxes by counties. Went from 15 billion to 30 billion. Personal income had only gone up 44%. Growth had only gone up 31%. To put this in perspective as to what the legislature was trying to do is the formula. Usually taxes are not simple, but the formula for figuring out how much property tax you're going to pay is really simple. You take value times millage equals taxes. You can't do anything about value because market dictates that. Well, can the legislature control millage? Yes, under Article 7, Section 9, in the decision of the Florida Supreme Court in Department of Revenue versus Glasser, and it, by the way, was never questioned in this case, the legislature has that authority to set millage for counties. So they got 67 counties. How are we going to do this? Well, they decided to do a compound growth rate of 2000, 2001, 2006, 2007, come up with a compounded growth rate.
Okay, it seems to me that you're arguing that 4D was passed for two purposes. One being that we know that these fire units, their revenues have grown in the past, and we shouldn't hold that against the counties in calculating their millage rate in the future.
Correct, yeah.
Or you can read it to say, you can read it to say that notwithstanding how much they've grown in the past, we still want to let them have 90%, 7% of what they had in the past.
97, yes.
97%.
Yes, Your Honor, 3%.
And they're arguing that the statute only accomplished, or the purpose of the statute was only to do the second thing I said.
They would like for that to be the effect, Your Honor.
Pardon?
They would like for that to be the effect, but that is not the
I'm
effect.
saying, so address directly to me, where looking at the statute, I can show that they intended both effects versus just the one.
There are three effects, Your Honor. If I may, if I could take you through the provisions of 200-185 paren 4 paren D. And this is what the legislature provided. This is the first thing. For the purpose of calculating maximum millage rates for 2007-2008, and I would call your attention back to the very first sentence of 200-185 paren 2 paren A, little a. It says the maximum millage rate that a county, a municipal service taxing unit of that county or a special district dependent to that county may levy by a majority vote of the governing body in 07-08 shall be determined as follows. And in this particular case, the paragraph that applied to Brevard County was 4, but any of the paragraphs 1, 2, 3, 4, or 5 apply. And it says, for any county for which the compound annual growth rate and total county ad valorem tax is levied as defined in 200.001 per capita for fiscal year, so forth. And council is correct. The legislature called for, in subsection 7 of 200-185, that the department calculate a compound annual growth rate. Now, the compound annual growth rate is supposed to include the county and its dependent districts. So the legislature did two things in 200.085 paren 4D. It has two purposes. We'll get to the third one in a moment. For the purpose of calculating maximum millage rates of counties and dependent districts. For the 2007-2008 fiscal year, under this section, which takes in paren 7, municipal service taxing units and special districts dependent to the county or municipality, the predominant function is to provide emergency medical or fire rescue services, shall be considered independent special districts. If the legislature had stopped right there, this fire district would not be included in maximum millage rate because it became an independent district. And the maximum millage rate only addresses dependent districts by not only the wording of 200.185-2A, but also the definitions in 200.001 that the appellants like to use. Those are general definitions. They include dependent districts. The legislature said, if you're a fire district, you're an independent district for 1 year. And then it went on to say, and shall not be included for the purpose of calculating maximum millage rate under subsections 2 and 3, but 3 is for municipalities. Well, if you don't include it, you can't include it. You can't put it in the compound annual growth rate because the statute there says growth rate for total county ad valorem taxes. The definition of total county ad valorem taxes is the county and its dependent districts. That's in 200.001J. So it has two purposes just in D alone. These fire districts are taken out of the picture. They're independent. We don't care about them. Now, what are we going to do with them? Well, in paren 4, A, B, and C, they dealt with independent fire districts. Since they created a whole bunch of them for 1 year, what are we going to do with them? We got to give them some kind of millage. They gave them a millage of 97%. It's just that simple. The trial court thought it was that simple, and it is that simple. The legislature has general statutes dealing with an issue, and then it has a specific exception which controls over the general statute. And no matter how you read this, no matter what section or subsection you look at in 20185, these dependent fire districts are out for that year from any of the computations, because if they weren't, it makes no sense. Thank you, Your Honor.
Okay, before you leave the podium,
Certainly.
and I might not have been listening,
Okay.
I stated two purposes for the statute,
Yes.
and you said 1 and 2, and I think you pretty much agreed with me what the two purposes were. And then you said you were going to specifically tell us what the third was, and I wasn't sure I picked that up.
Excuse me, Your Honor. I apologize for that. The third one was when I said, well, what are we going to do with them? And in paren 4, paren A through C, they gave them a millage rate.
Okay, thank you.
So those were the three purposes. Thank you, Your Honor.
Very briefly, Your Honor, to take you back to Section 4D and why we're having a difference with the Department of Revenue and why they don't see it the same way we do. Subsection 4D says at the very beginning, for the purpose of calculating maximum millage rates under this section.
Okay, stop at that. What is the definition of section for the statutes?
I'm sorry?
What is the definition of section for under the statutes?
Well, assuming that means 200.185.
So why doesn't, as Mr. Millichamp kind of argued, why doesn't by saying under this section cover the entire chapter?
Well,
and you say you want to exclude it under 7, not the entire chapter, the entire statutory section.
I will, let's take it for granted that it does for a second. Let's take it for granted that it does. It says for the purpose of calculating the maximum millage rate. It does not say for the purpose of calculating the compound annual growth rate.
But isn't part of that calculation calculating the annual growth rate?
Calculation of the annual growth rate is a separate function under subsection 7. It's DOR's function. Calculation of the
Isn't it a whole process to determine the maximum millage rate? It seems like you're trying to break the process up and.
Well, there are two different processes involved in the statute. The statute says you make a compound annual growth rate determination, which includes all MSTUs, all county-dependent special districts, and the county's general fund. That's the definition under section 200.001 paren 8J. That's how you make that determination. Then it says you make a maximum millage rate calculation under subsection 2, which is an individual calculation for every single of the 18 taxing authorities that the county levies for. That's a separate calculation for each individual one. It's not a general overall county calculation. The compound annual growth rate is an overall county calculation that sets up a legislatively prescribed percentage that the legislature picks up. They're the ones that set the percentage. There's two components to the maximum millage rate calculation: the percentage established by the legislature and the rollback rate, which is individual for each taxing authority, which is why you have separate calculations for each authority. But the CAGR is in subsection 7. That's an overall county calculation that requires the DOR to include, by definition, all MSTUs. It doesn't exclude the fire MSTU. If subsection 4D had said for the purpose of calculating maximum millage rates and the CAGR under subsection 7, again, I would agree with the department. But it doesn't say that.
Thank you. Next case.